Hello and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Rachel Moran, Assistant Professor of Law at the University of St. Thomas School of Law. We will discuss her article, Police Privacy, which will be published in the UC Irving Law Review. So welcome to the program, Rachel.
Thanks so much, Brian. I appreciate you having me. I'm excited to be here.
Yeah, so I was saying to you a moment ago, I just found the subject matter of this paper absolutely scandalous and appalling. And I can't wait to talk to you about it because I think that a lot of people don't realize that this is even happening. So maybe you could start by just saying a little bit about what is police privacy anyway? I mean, what kind of information about police is private? And if I go to ask for records about the activities of the police and disciplinary records and so on, what happens? What do I get, if anything?
Yeah, well, it varies so much depending on state, but in a lot of places you get very little. And that's really what the background behind this paper is, that in many states, and the paper discusses there's variety among jurisdictions, but in many states, if a member of the public is trying to find information about complaints filed against an officer, allegations, for example, of perhaps excessive force or tampering with evidence or any variety of allegations you might come up with involving a police officer and potential misconduct, in many states that's ranges anywhere from impossible or difficult to obtain for a member of the public. And there's a lot of controversy around that. I appreciate you sharing that you think it's scandalous. There are heated debates nationwide about this very topic. And so that's the context of the paper.
Right. So I guess it differs from place to place. I guess the obvious assumption would be that in like super conservative places, it's really hard to get police records. But in like real liberal places like California and New York, it's like no problem. They're real forthcoming.
And what's so funny is that this is really defies political boundaries in many ways. A lot of people would make that exact assumption. In fact, New York and until very recently California were the two most restrictive states in the nation in protecting or preventing the public from accessing records of police misconduct. A lot of times what you'll find is that it's actually what might be referred to as the red states or the more conservative states that have a greater respect for open records. And therefore, because of that, it may not be due to any particular desire to protect the police, but their open record laws in general are much broader and more generous. And so police misconduct records fall within that. And there are roughly 12 states, depending on exactly how you want to break it down, that do permit a presumption of public access to these records. And it spans the spectrum of more traditionally blue and red states.
I want to know how this works in practice, right? So, I lived in New York for a long time. Imagine a situation where I feel like I've been the subject of police misconduct and I want to bring an action against the police officer and against the police department for injuring a 1983 action or some kind of civil rights action, right? And I want to find out, who this officer is and if they've done this kind of stuff before. Because if they've done it before, then presumably, that's going to strengthen my case that they've done something wrong. I go to the police department or I have my lawyer go to the police department. What do I get?
You get probably nothing. And just to make the fact scenario clear, you haven't yet filed the civil rights suit. It might be different if you're actually in the context of ongoing civil rights litigation. But if you're trying to figure out whether you've got an officer who you'd have a viable suit against, and in that context, whether the officer has a pattern or a history or practice of engaging in misconduct, you're not going to get much of anything if the state is New York in particular. And that's because of a law. I think it's sort of ironic. It's called Civil Rights Law, Section 50A. It's the subject of extensive dispute litigation. It's been around since the 1970s. But in practice, what that means in the vast majority of New York jurisdictions is that if you try to go to a police department and request the personnel file or the misconduct records of police officer X, you're simply going to be told that that is not available to you. Point blank, end of story. You can't get the records.
Wow. Okay. So maybe we could take a step back then for a second and just ask, like, why does this matter? I mean, like, what do people want these records for? What kind of records do they want? Sort of what's the context in which these requests are being made? And, are there new reasons that people want these records, or have sort of the practice around like asking for records or what people want to do with them changed over time?
Well, it's certainly become more and more of an issue. I think journalists are more frequently trying to access the records. A lot of the disputes around these records come from either civil rights organizations or newspapers or other media organizations who are trying to get access. I lived in Chicago for 10 years and was an attorney there. And so an example very familiar to me is the Laquan McDonald shooting. There was an officer named Jason Van Dyke who was recently convicted of murdering a young black teenager, Laquan McDonald. Illinois has changed its laws in recent years, but for many years, records of allegations filed against Chicago police officers were not something the public could access. And after this shooting, it came to light that Jason Van Dyke had, in fact, 18 prior allegations, ranging from use of racial slurs against civilians to excessive force to a variety of other things. And more media outlets, since police misconduct, I think, is becoming increasingly part of the national conversation, has been in some way for decades, but I would say probably in the last 5 years or so, really a significant topic of conversation. A lot of media outlets are trying to obtain information about how police departments are doing in terms of disciplining officers who are receiving complaints. Personally, the way I got interested in this was partially from a litigation standpoint as a public defender, but also once I got into academia and was one of the things I was looking at is the ineffectiveness of internal affairs review in police departments. And internal affairs departments tend to have just atrocious track records of sanctioning or disciplining officers for alleged misconduct. And so then as a spin-off, you start wondering, okay, well, does anyone know this? And does the public have access to data about these kind of poor track records, and then specifically information about officers individually? And a lot of times, I mean, again, there's some variety here, but a lot of times the answer is pretty much no.
Wow. So are these limitations going not only to information about particular officers, but even kind of aggregate data as well?
They can. In New York, that's one of the topics of discussion right now, but the New York Police Department is refusing to release even anonymized data about officers, just redacted, no identifiable information, data about officers and complaints. And that has been, they got so much flack for that then the police department proposed releasing some information, and the police union immediately fought back, saying that even anonymized data would violate the officer's privacy, which is sort of a fascinating thing to try to tease out, but that's the stance of the union.
Okay, so is this a long-standing thing? I mean, has it always been the case that obtaining records about police officers and police misconduct has been limited or prohibited in some states and permitted in others? Like, how has this changed over time?
Well, so the New York and California laws that I referenced earlier that are some of the most restrictive came about in the 70s, and they actually were direct responses to previously, so defense attorneys in criminal cases were able to obtain records of police histories of misconduct or allegations, and then were using those to impeach the officers at trial. in response, the unions, as they became stronger, fought back, arguing that it unfairly discredited the officers or was a fishing expedition for misconduct. And that's how those laws came to be. So we're tracing back about 40 or not quite 50 years. A lot of states, though, actually don't single out law enforcement specifically for protections. They just have more generic statutes saying that personnel records of public employees are not accessible to the public. And I'm not sure how long those date back. They're long standing, but I did not in my piece try to trace each one back to a particular date. So I don't know if I could speak to that. And then in recent years, there definitely has been some changes, both for and against privacy, I guess I would say. Some states are, like California, are changing their laws to make these records more accessible to the public. Other states are doubling down, and you've got legislators on either side proposing laws that would increase public access or prohibit.
That's interesting. So it's like a smorgasbord. It almost sounds like
yeah.
of different laws depending on where you are. And in your paper, you talk a little bit about how we might think about that. But maybe, maybe we need to look at it from the other perspective. What's the rationale for this? From my perspective, you tell me these records are private and non-disclosed. This sounds bizarre to me, but there's got to be a reason. What reason is given for why these records shouldn't be released?
Sure. Well, so the proponents of police privacy in this context tend to be the unions, and they're powerful. They have a lot of legislative backing in many, I'm generalizing here, but in many states and many areas, police unions have a lot of money and a lot of, sway with legislators. And those tend to be the strongest proponents of privacy. And what they say is, the reason I latched onto privacy is because at face value, that's just what they say. They say this would violate the officer's privacy to give the public access to the kinds of misconduct records that I talk about in the paper. If you dig a little deeper into what privacy means, sometimes you don't find anything, but sometimes you find, okay, they're talking about, they're suggesting a risk of retaliation against the officers, potentially even physical harm or employment harm. Somebody might be terminated unfairly because of records that were made accessible to the public. In some states, this has come up in Missouri. The fear is that officers will be, if information of a past history of misconduct is known, they'll no longer really be viable as witnesses at a trial, and that would harm their employment status, etc.
Good, right?
That is certainly the stance of people on the other side. Is, well, that seems appropriate.
Wow.
Yeah. So the harms they're suggesting, some people would say, are just appropriate remedies.
Yeah. Is there any evidence presented of officers being targeted or treated unfairly on the basis of the disclosure of this information? It sounds like it's only a percentage of departments that limit access. So do we see like a tidal wave of retaliation and targeting of officers in states where the information is released?
Yeah, I'm so glad you asked that. That's one of my next pieces. So I'm doing a modest empirical project trying to get data in the states that do have a presumption of access to these records to try to figure out, are they actually being used in a way that creates identifiable harm to the officers? There's really, my suspicion is no, but there is a huge lack of empirical research on this topic. I cannot point you to specific data to say that it is actually harming officers or that it is not. I certainly have my suspicions about this, but I can't point you to data, and that's leading my next piece.
Yeah, and that sounds fascinating. I look forward to reading it. Just on its face, it seems to me that the people who are arguing on limiting access to public records really ought to bear the burden of showing that the parade of horribles from disclosure is actually likely to materialize. I mean, have the police unions in New York and California produced any evidence to support that argument?
Not that I know of. I've not seen in the litigation that I've followed, or even in just the news reports, I've not seen identifiable data suggesting that there is harm to officers, other than in some, as I mentioned earlier, there are definitely some instances where officers have, for example, been put on what's called a no-call list by prosecutors. So they will refuse to call officers to testify if there's been allegations or sustained findings of misconduct against those officers. That's a dispute in Philadelphia too, with the DA Larry Krasner there, who's creating some reforms. It's been a dispute in St. Louis with a new reform-minded, more progressive prosecutor. So that is one. Again, I think we could debate whether that's actual harm, but that is one consequence that I could point to in specific places. Other than that, in terms of like a fear of physical harm, which is often brought up by police unions, I don't want to say that it's never happened, because I can't say that, but I'm not aware of any such instances.
Yeah, I mean, it just seems to me like in the case of Krasner and whatnot, I mean, they're quote unquote blacklisting officers, but they're doing it because they're liars. I mean,
right?
We don't want liars on the stand, right? I mean,
yeah, and I mean, the pushback that someone else would give you is, well, maybe these findings about the officers aren't reliable, though. So maybe to the extent we don't trust the internal affairs or whoever is reviewing these allegations to be doing a good job either way, then maybe we have a genuine concern about these findings against the officers being reliable. And I can somewhat, I am moderately sympathetic to that concern.
Yeah. I mean, I guess it just seems to me like any witness who has a history of, disciplinary infractions or, falsehoods is, the credibility of their testimony is going to be impeached. I mean, why should it matter if it's a police officer or a civilian or, someone who's in prison?
Right. Yeah. And, if you look at the rules of evidence, there are many ways in which lay witnesses' credibility can be impeached. And certainly that's, a concern, is that in the context of litigation specifically, we need to be able to have access, or defendants need to be able to have access to the same kinds of impeaching material about officers. It's a little bit different if you take it outside the context of litigation, where it's just the public seeking access. But I think the litigation context is the most overt point, and yet still a situation where routinely criminal defendants have trouble accessing these records.
Yeah, well, in your paper, you suggested it's not just criminal defendants, but in some cases, even prosecutors have trouble accessing these records.
Yeah, so that's the situation in California. And I keep referencing California having recently changed its laws. What it did is to go from a late last fall, effective January of this year, it now makes certain classes of allegations accessible to the public. There are still a large number of records that the public cannot access. But the way California was particularly extreme, and in some ways still is that the police department couldn't even disclose this information. Well, prosecutors couldn't demand the information. And even when perhaps a police chief or a sheriff's department wanted to, as a matter of getting rid of certain officers or reforming the department, they actually weren't allowed to disclose the information, even to prosecutors who may be calling these people to testify at trial. And that's why California had probably the title of the most draconian law enforcement records policy, and which has now been somewhat reformed and is the subject of massive controversy, the new law.
Yeah. I mean, it just seems so bizarre to me that we would limit the prosecutor's ability to do justice to the extent that, like, we still have faith that that's a realistic part of the prosecutor's obligation. But I mean, to say to them, we're going to deny information that you would need to evaluate the credibility of your own witness. I mean, that just seems totally bonkers to me.
Yeah, it's pretty wild for sure. And there's been some good scholarship around that, just specific to California, around how crazy that particular law is. But then there are other states, not quite as extreme, but who basically take the turn a blind eye approach and say that if a prosecutor knows of and has access to the information, they have to turn it over as a matter of Brady material. But if they don't know, they're not required to find out.
Aha.
Yeah.
And in those situations, can the defense do it independently, or do they have to rely on the prosecutor's quote discretion in terms of determining whether or not they want to check the credibility of their witness?
Well, in those situations, typically what has to happen is that, in many states at least, is that the defendant has to file a motion for a subpoena ducis tecum requesting records, but it's a catch-22 because a lot of these states, the subpoena ducis tecum motion will only be granted if the defendant can make a showing that the records exist and of what they would say, which of course is impossible. Exactly.
Oh,
thank you for the appropriately timed laughter.
Come on.
Yeah, and that's the reality of that's actually how it works in many states.
Oh man. Well, I gotta say too, like from a broader structural standpoint, reading your paper, I just couldn't get away from the irony of police departments and police officers and police unions insisting on, piously insisting on this need for protecting the privacy of the officers. I mean, given how excessively public information about every other aspect of the criminal justice system is. I mean, we're publishing people's mugshots and distributing, videotape of them being arrested and being interrogated and all the documents about them, and then putting people on public registries for the rest of their lives. And how do we make it easier for people to find out information about members of the public who've been convicted of a crime or even just, charged with a crime? I mean, it's very hard for me to sort of see how it makes sense to be super public when it comes to private citizens, but super private when it comes to government agents.
Yeah, there's a huge disconnect there. And what, I'll give a shout out to Kate Levine, who's written an article somewhat similar on the notion that what we should really be doing in this situation is seeing how officers are protected and treating other folks in the criminal system the same way, instead of seeing how defendants in the criminal system are exposed and saying police officers should equally have a lack of privacy. It's an interesting take on the situation. What I really wanted to do with this piece is talk about what it actually applies some privacy theory, because the debates are so often outcome oriented around this topic. So you can make a great case for why the public should have access to these records. You can make I would say, more marginal case as to why police officers might be, somewhat speculatively, but might be harmed by giving the public access. What people tend not to do is say, are these records actually the kinds of things that are considered private? Because the privacy word is just bandied about, and people say, well, it should be overcome by the public interest or it should be respected. What I wanted to do is say, are these actually even the kinds of records that the law considers private? And so that was the impetus behind taking a deeper dive into privacy theory, which is part of what this piece does.
Yeah. So what do you think about that? I mean, if you were to disaggregate the different kinds of records that are really at stake, I mean, what should policymakers, courts, whoever be looking at in evaluating when disclosure is appropriate and kind of policy positive, and when there are legitimate privacy concerns that might counsel against disclosure or counsel in favor of redaction or something like that? What should they be looking to?
Yeah, well, I think the first thing courts should be asking is what kind of information is in other contexts deemed private. So going to the informational privacy body of law in particular, what's interesting is most courts, the U.S. Supreme Court has never definitively recognized a constitutional right to informational privacy, but they've hinted at it. And what most courts have done in the context of other, so taking it out of the law enforcement context, other kinds of informational records, they recognize a right to informational privacy in pretty limited context, actually. And the context makes sense to me. There are things like medical information, sexual history information, mental health. Sometimes financial records fall into this category, but usually courts use words like intimate or personal information is the kind of thing that's protected by a right to informational privacy. And in those cases, the burden should be on the person seeking access to the records, and it's usually some form of intermediate scrutiny. Not everyone applies the same standard, but there's a somewhat of a burden placed on the person seeking access to overcome a presumption of confidentiality in these intimate or personal records. Applying that kind of framework to the police misconduct records context, there are a few kinds of misconduct records that may fall into that category, but the vast majority do not. An allegation that an officer beat someone up during a traffic stop, or lied on the witness stand, or even, did something much less serious, like showed up late to work, which could be deemed misconduct. That's not intimate and personal information. So I think when courts are looking at this, they should actually be, my ultimate conclusion in the paper was that many of the kinds of things that are deemed misconduct records just don't fall into the category of private information. So the right shouldn't be recognized, in which case the public should have access if they can. I suggest a number of public interests that might be at stake here, but if they can show an interest, then I think they should have access.
Yeah, I thought it was interesting the way you used like Nixon v. General Services among other cases to sort of make that point. The idea that if you're exercising the power of the state in whatever capacity, whether you're the president of the United States or just a police officer, in a local police department, in both cases, so long as you're exercising the power of the state, that just doesn't seem like the kind of thing that's private to me.
Yeah. And there have not been a whole ton of courts that have ruled on this issue, but the most clear-cut instance when something should not be deemed private is generally when it's a police, in the context of law enforcement, when it's an on-duty incident involving sustained findings of misconduct. So someone has actually concluded that yes, the police officer did engage in misconduct and it was on duty. There's really a minimal case at best to be made that in any way implicates the officer's privacy. You get closer when it is off-duty misconduct that still might have some relevance, something that the public might want to know about, or if it's like an officer with an alcohol problem, for example, you're getting a little bit closer to medical or mental health information there that could be deemed within the context of records ordinarily deemed private. You've still got the issue, though, that this is a public employee with the power of the state behind it. And so even in that context, I'm not at all sure that the record should be deemed private, but it's at least a closer call there.
Yeah, and you also talk in the paper about autonomy privacy and not just informational privacy. Do you think autonomy privacy and that kind of conceptual category of privacy claims has any leverage in this circumstance, or is it just not, like, with respect to police and police records, or is it just the kind of it doesn't line up, doesn't really have any kind of bearing on this kind of material?
Yeah, that's such an interesting question. I will say that I don't give that argument any credence or really time in the paper. I tend to think that autonomy has very little impact, but the autonomy strand of privacy is much more traditionally associated with things like marriage, child rearing, education, procreation, things like that. Which is not to say, though, I think, I'm not going to present myself as, there are other privacy scholars who have put more thought into that. And I'm sure that someone could come up with an argument that a police officer's autonomy, his decision making, etc., could be impacted by, or implicated at least, by this issue of whether the public has access to misconduct records. I think it's a stretch, but I don't want to rule it out entirely. The confidentiality strand is the much clearer strand to me of where informational privacy concerns are implicated.
Cool. Well, Rachel, it's been great talking to you. And I was wondering if, in closing, you might say a little something about where you see the kind of timeline going forward. I mean, are we seeing more liberalized access to police records? I mean, you've mentioned a lot of pushback from unions. Do you think that ultimately we're going to get access in a lot of these places that have been restricting it for, a surprisingly long time?
I think that things are going to shift in New York. There's so much heat and so much litigation around this issue, and some really powerful arguments being made that the history of refusing to give public access to these records has allowed for a police department that has far too many problematic officers on the force. I think California is really the beta test here. Having so recently changed its laws, even since January 1st, when the new law allowing some access to public access to some of the records has come into effect, numerous lawsuits have been filed. Police unions have pushed back, have filed lawsuits. Some departments are just refusing to release the records. Some departments have even been accused of destroying the records. Seeing how things shake out in those two states over the next, really, I think 2 to 3 years will be extremely informative in how the rest of the nation responds. But I can say that there are people doubling down on both sides of this for sure.
Cool. Well, thanks so much, Rachel, for coming on the program. I really enjoyed talking to you, and I look forward to seeing your next project.
Thank you, Brian. I appreciate it.
Imagination is funny.
Imagination is the backdrop in the new John Cassavetes film starring Ben Gazzara. It's a story written in the blood of our times. It's about violence, the people who create only to give up everything they love for the respect they have for the establishment. It's an anti-gangster film. See The Killing of a Chinese Bookie.